Can you hear me?
Yes.
Yes.
Great.
Great. Well, greetings, everyone. And we have a large crowd here today. Thank you very much for joining us for this roundtable discussion on the unique status of international financial institutions in international law. As Britta mentioned, today's topic is climate, SDGs, debt, and the international responsibility of international financial institutions. Do the articles of responsibility of international organizations need to be updated? We're joined by two terrific speakers known to everyone in the field of international financial institution law, international organizations, namely Sheila Braca-Musime, who is the Deputy General Counsel for Operations at the World Bank in the Legal Department, Office of General Counsel, and Christina Daugiris, who is the Francis Allen Professor of Law at the University of Michigan. After our roundtable discussion, Professor Bradlow and I invite you to join us around 10:15 when we'll have a break to discuss the launch of a new interest group on the international law of development. Please note that if you have questions, to please put them in the chat. I think identify yourself as well. We'll do our best to include those questions. And also, if you have questions about the proposed interest group, you can engage with that at that particular time. So with that, I will turn it over to Professor Danny Bradlow, University of Pretoria, South Africa. Danny, over to you.
Thank you, Charles, and welcome everyone. It's a great pleasure to welcome you to this meeting. As Charles said, we have a very interesting topic and a wonderful panel to talk about. A couple of things to start off with. One is when we talk about the IFIs, just to clarify, we're talking about the multilateral development banks plus the IMF, which is a big universe as well. Second thing, as Charles said, is the articles on responsibility of international organizations deal with the responsibility of international organizations for their wrongful acts. Article 5 of the ARIO says the characterization of an act as wrongful is governed by international law, which means that the substantive obligations of international organizations, and particularly for our purposes, the IFIs, is going to depend on international law. So it seems helpful for us to begin our discussion by focusing on the substantive legal obligations of the IFIs. And it's particularly important to do this because it's becoming a much more complicated topic. Operationally, the roles that international organizations play can vary very dramatically. So for example, operationally, the differences between a World Bank funded loan to an infrastructure project and a UN peacekeeping operation are extremely difficult, or extremely different. But whether that's legally significant, of course, is a separate question that we need to look at. Secondly, the operations of the IFIs are becoming even more complicated because they're taking on new roles. They're being called upon to address the global challenges that are emerging from issues like climate change and pandemics. And they're being and social challenges like inequality, conflict, and violence in their projects, and other sorts of financial operation. All of this is pushing the IFIs to deal with their member states and the residents of their member states in new and different ways, which requires them to think about what are the impacts of this and what does this mean for their obligations and their responsibilities. And so that's the issues we want to focus on today. And so the first question I have for Christina and Sheila is, what are the similarities and differences between the international legal obligations of the IFIs and those of other international organizations? Does the different types of operations they undertake have legal significance, and what is that? And maybe to start, let's start with Christina, and then we'll come to Sheila after that.
Sure. So thank you, Danny. Thank you, Charles. Thank you, Sheila. It's really a pleasure to participate in this panel today and to have an opportunity to discuss these very important issues. So Danny, I'm going to get to your question about potential differences in the obligations of different international organizations. I'd like to start by stepping back for a moment just to frame our overall topic. So mostly we're focusing on the articles on the responsibility of international organizations, which were produced by the International Law Commission. These articles are limited in scope in some very important ways, right? So they kick in only when there's been a violation of international law. And so this is exactly why Danny has started the conversation by asking, well, what are those primary obligations of international organizations? Because we need to know what those are in order for the draft or the articles on the responsibility of international organizations to have any application at all. This is also important because it highlights the limited scope of the articles of IO responsibility. And here I want to highlight that there are many ways that international organizations might fail or might cause harm that don't violate international law, right? They might endeavor mightily, but fail to advance the purposes that they were created for in meaningful ways. That's not necessarily a violation of an international obligation. Similarly, they might cause harm in very prosaic quotidian ways that don't entail a violation of international law. And so when we're thinking about the role that these articles of IO responsibility might play, I think it's really important to keep in mind that they can never be more than a partial solution to some of these important issues about the accountability of international organizations and how we ought to respond when they fall short. So to go to the question that you posed about what are some of the differences in the primary obligations, the obligations under international law across different organizations, I think it's helpful to note that there are some areas of agreement and some areas of contestation here. So we might divide the answer into a couple of categories, right? If one question is, what are the sources of international law that create obligations for international organizations? I think pretty much everybody would agree that their own charters can be a source of obligations for the organizations. I think pretty much everybody would agree that treaties to which the international organization is a party with another state, right, perhaps a headquarters agreement, or with another international organization, can be a source of obligations for international organizations. Customary international law and general principles are a little bit more contested. So the International Court of Justice has said in an advisory opinion that international organizations, as actors with independent legal personality, are bound by, I don't have the exact language in front of me, but essentially applicable customary international law and general principles. And so this raises the question of, well, what's captured by that word applicable, and how much weight do we put on this ICJ opinion in the first place, which addressed this issue in the course of a completely different argument, right? The question was, do international organizations have plenary authority to choose where their headquarters are going to be? I think the answer to that question is clearly no. So this important statement about the sources of international organizations' primary obligations was really made in passing in the course of addressing another issue. So if you look at what scholars say, there's some disagreement. So my own view is that customary international law and general principles, at least as a default matter, do bind international organizations, but there are others out there who disagree and say, no, really, it's only some subset of customary international law and general principles. So even when we're talking at the level of what are the sources of international organizations, international obligations, I want to highlight some of that contestation. I'll say that contestation persists partly because international organizations themselves have been extraordinarily reticent to take public positions on this question. So I have spent a lot of time digging for engagement by international organizations on this question. We can talk about some of the places where international organizations have taken a public position, but I want to highlight that this uncertainty persists partly because of the absence of sort of public position taking and engagement by international organizations on this question. Okay, right, so those are the sources. When we get into what are the variations within those sources, right? So charters of international organizations vary. So to the extent that charters are a source of obligations, those are going to vary across international organizations. International organizations vary in the treaties to which they are parties, right? So there too, there's going to be some variation. If we're looking at customary international law, Danny, you started by pointing out that the activities that international organizations engage in are very different, right? Peacekeeping is very different from the kinds of lending that the IFIs do. What I would say as a first cut answer, and there's certainly more to talk about here, is that the differences in the activities, in my view, don't mean that there are differences in the obligations that international organizations have under customary international law. And I think here it may be helpful to analogize to states, right? So states engage in a wide variety of different activities. They don't all engage in the same package of activities. And yet, for example, to the extent that there are rules relating to the law of the sea that are a part of customary international law, those rules aren't different from states with coastlines and landlocked states just because they're differently situated, right? Or different in the extent to which their activities are going to potentially bump up against those rules. So my first cut answer is, notwithstanding those differences, I think the baseline obligations are going to be the same.
Great, thank you, Christina. You've given a lot to. There was a great way of laying out the lay of the land, and you've raised a number of important issues. Some of which, Sheila, just before I hand over to you, one is that just because an international organization in doing its mandate might cause some harm, that doesn't automatically lead to a wrongful act and responsibility, is the one thing. And secondly, that differences in activities don't mean differences in the legal obligations. So with that, let me firstly just remind people, if you would like to put in questions, to please put them in the Q&A function and we'll feed them into the discussion. But Sheila, let me hand it over to you to answer the question, and particularly from the position of the IFIs.
Thanks so much, Danny, and good morning, good afternoon, good evening, everybody. I am just really grateful to Danny and Charles for pulling together this event, and to Christina for being willing to engage us and to provoke us into discussing this topic that she says we've been reticent to take public positions on. But to start with, I will give a caveat. Obviously, the views and opinions that I will express in this discussion are my own. This is not a formal World Bank position on the subject. That said, it's a subject that that is very timely for us, given the calls for more responsibility for IFIs, for international organizations more broadly. But before really getting into it, I just want to talk about the timing of setting up this, launching this new interest group. Very grateful to ASIL for all the work that it has done over the years. And I have many colleagues, many of whom are on the call even now, who are participating in different interest groups, including the one on international economic law, the one on refugees and migration, and international organizations. But really, given the interest of the topic now, and the scope, the wide range and scope and number and sizes of development initiatives that international organizations are undertaking, I have to say that an interest group like this is actually very critical, and I'm glad that we get to participate in the launch and be part of this broader development topic. So Danny, to your question specifically on the similarities and differences, there's a lot I agree with Christina on that she just spoke about, but there are some marked differences that I hope I will be able to lay out in the way we think about this topic, the way I think about this topic. Probably the most uncontroversial statement I will make is that IOs are very different. They're different in origin. They're different in the reason for their existence, the problem that they were set up to solve. They're different in mandate, in membership, in staffing, in the nature of their immunities, in their sizes, and so of course, then the nature of their international legal obligations naturally are different. And the way that they enter into them is also very different. For instance, as you mentioned, Danny, when you think about the United Nations, you think about immediately what is their purpose, why were they set up? And it really was to, quoting from Article 1 of the UN Charter, was to maintain international peace and security. Very different from that, you have the World Bank and its institutions, IBRD and IDA, looking also at their articles. Just to summarize, they were set up, at least IBRD was right out after World War II, and it really was to assist in reconstruction and development of its members. And in achieving that purpose, I think the founders were very clear that to achieve that development mandate, there had to be a political prohibition. And this makes it markedly different from the United Nations and many other IOs, which have a very political mandate. And when we go down the list of IOs, take, for instance, NATO. NATO is a security alliance of 30 countries from North America and Europe. Its fundamental goal is to safeguard the allies, freedom and security by political and military means, right? Then you have Interpol. It has a mission to help police work together to fight and prevent international crime. You can even go down to the African Union and some of the other regional, if you want, continental bodies. And the African Union took over from the OAU, which was really set out to help post-colonial Africa in finding its place. And its mission is to defend sovereignty, territorial integrity, and independence of member states, promote peace, security, and stability on the continent, promote democratic principles and institutions, popular participation and governance, promote and protect human and people's rights, and so on and so forth. And just looking at NATO and the UN, for instance, where actual boots on the ground are sent into countries to either maintain peace or to actually carry out military missions. it raises its own set of questions and obligations under international law, which are very interesting to ponder, where you have an organ that doesn't have its own citizens and doesn't have its own troops, but it's sending troops into a country whose obligation is that when the troop commits a wrongful act. And so the way we look at responsibility of these organizations is by its very nature going to be different because of the roles that they play in the international sphere. And the role that they play vis-a-vis citizens, the way that they are set up with states being part of their establishment. But it's important also to say that these distinct mandates are critical, right? They help to make sure that the many development challenges that you highlighted at the onset, climate, debt, and all the other challenges that are laid out in the SDGs are not left unattended by the panoply of these international organizations that exist. And so I will say very clearly, obviously, we need the UN as much as we need the MDBs and all the other IOs to help make sure that people are lifted out of poverty and can realize their individual and corporate aspirations in a peaceful world and on a livable planet in a sustainable way. But bearing this,
Please,
sorry.
go ahead.
So, but bearing this in mind, we can't talk about responsibility, as Christina said quite clearly. We can't talk about responsibility without talking about what their actual obligations are. And the opinion that she spoke about from the advisory opinion from the ICJ in the WHO case, it said something, actually, there was a nuance in what this opinion said. It talked about each individual international organization. We'll talk more about how it broke down sort of these general principles of international law that folks have interpreted to include customary international law. But what was very clear is that the single most important source, and this is where I agree with Christina, is the single most important source of international legal obligations for IOs is their own constituent documents. And flowing from that, obviously, we have their policies and procedures that are approved by the organs that set up or govern these institutions, in our case, our board of executive directors. And then we have the sort of treaties that are entered into, the international agreements that we are entered into, and all these were highlighted in that ICJ advisory opinion. We enter into international agreements with borrowing member countries, and within the four corners of that agreement, obligations are set up on both ends, between the state and between the international organization. And in the case of the World Bank and many of the MDBs, you see that they've set up independent oversight bodies to in a way, promote compliance, right? And on our end, we have the inspection panel, which looks at whether bank staff have complied with environmental and social policies in the context of operations that are financed here. But the more contentious part, as Christina highlighted, and here's where we kind of arrive somehow differently, is where the ICJ talked about undoubtedly it mentioned the constituent documents, it mentioned the treaties that are entered into, and then it mentions these general rules of international law, under their constitutions or under international agreements to which they're parties. But these general rules of international law is something that is a subject of contention. And my first inference is that it was not the ICJ's intention to establish that the entire corpus of customary international law is applicable to international organizations. And first of all, if it wanted to say that, it would have said that specifically. But most importantly, customary international law is ultimately based on state consent. And international organizations have not contributed, I would argue, to that. And so it's very plausible that the ICJ's intention was to indicate that international organizations would not be able to depart from, if you want, the general infrastructure of international law, that is, rules on the making, application, and enforcement of international law itself. this understanding, I would argue, is corroborated by the fact that when the advisory opinion was rendered, the possibility of wrongdoing by international organizations was largely a theoretical construct. And so the argument I would put forward is that international organizations should only be bound by international obligations that they have voluntarily assumed under international law. And in the comments, I think that various international organizations put forward when ARIO was being drafted were very much along those lines. And in fact, in the 2009 report of the International Law Commission, which was related to what was Article 9 at that time and is now Article 10, it mentions that for an international organization, most obligations are likely to arise from the rules of the organization, meaning in particular constituent instruments, decisions, resolutions, and other acts of the organization adopted in accordance with those instruments that established the organization. But Charles, to end, I just want to make it clear that even though we are not bound by quote unquote sort of general principles of international law that are entered into by states or by other means, I have to say that the World Bank has been extremely committed to the many global challenges that you highlighted. Take, for instance, our voluntarily taking upon ourselves to align all our financing with the Paris Agreement goals, take the work on carbon markets, for instance, take the work on the pandemic response. I think the World Bank and the other IFIs are fully aware of the critical role that they play in helping member countries navigate global challenges. And so these voluntary commitments undertaken by the bank to fulfill its mandate under the constituent documents really help countries, but keeping in mind that those member states are the ones that sort of own these obligations, and we come along voluntarily to help them in line with our mandate. Thanks.
Thanks, Sheila. Charles, go ahead. I know you wanted to say something.
No, that was a fantastic response. And I know Christina is going to want to reply, but I want to feed into both Christina's response and also to you, Sheila. As you quite rightly pointed out, there are different responsibilities depending on the charter. I think question is that have we seen for financial institutions, both international and even at the domestic level, an evolving sense of responsibility when it comes to their due diligence, to their supervision, to the monitoring that's really the unique aspect in the international organization strata that applies to IFIs. And particularly the question has become more prominent as we've seen the tremendous impact that international financial institutions, the World Bank, IMF, have. Probably, I hope no one from WHO is listening, but I would say that the impact is much broader across society. And so the question is, the evolving sense of accountability, has it caught up with these due diligence, design, supervision type responsibilities of IFIs? And do the articles really speak to it? Because they really are quite limited in terms of looking at a commission of a wrongful act. There's not much that really helps us there, I think. So whoever wants to go first, Christina or Sheila.
Christina, do you want to go first and then?
Sure. I'm happy to jump in first. And let me just start by saying again, I'm really so delighted to have this opportunity to discuss these issues with this group. So first, let me highlight some very important areas of agreement with Sheila. So absolutely, international organizations are very heterogeneous, and international lawyers actually tend to focus on a tiny fraction of all of the organizations that exist, right? So the UN and the UN system organizations plus maybe the EU and NATO, I think, get almost all of the oxygen in the room, when in fact those organizations are vastly outnumbered, as Sheila said, by smaller organizations, by regional and sub-regional organizations that take on an extraordinary range of tasks, right? We've got the community of Portuguese-speaking countries. We have the International Pepper Community. We have the Desert Locust Control Organization for Eastern Africa, and their mandates, the breadth of their mandate, the breadth of their membership, all of that varies dramatically. So emphatically, yes, on that point. And I think part of what is, I think, shaping the discussion here in the background is a sense of unease and uncertainty, right? Given that dramatic heterogeneity among international organizations, are we really confident that they have enough in common to be bound by a single uniform set of rules, right? And I think that this unease applies both at the level of primary obligations and also at the level of secondary obligations, right? Those rules of responsibility that lay out what the consequences are. And so I think where that leaves us, I think, as scholars, one important question as well. So let's dig into this question, right? Are international organizations heterogeneous in a way that matters, that means that their obligations ought to be different, right? That we can't have the same set of rules binding all of these organizations as a category. And what I'll say is here, I'm in the midst of undertaking a project that involves gathering the charters of all of the post-World War II organizations that my co-author and I can get our hands on. So we're trying to confront this question directly. I should say I have not yet seen good examples of dramatic mismatches, right? I have not seen the case for why the Articles on the Responsibility of International Organizations could not possibly bind the International Pepper Community because, right, something. I'd love to know what that something is. So the more examples of mismatches that can be identified, I think the more we can directly confront this unease and this uncertainty about the universe of international organizations. It's helpful, I think, to go back and look at another effort to articulate sort of a single uniform set of rules that would apply to international organizations. And this is developing the Vienna Convention on the Law of Treaties, to which international organizations are parties, right? Either with other IOs or with states. And that effort followed the development of the Vienna Convention on the Law of Treaties between states. It yielded a convention that still doesn't have enough parties to enter into force. But I think it speaks to a couple of things, right? So one is, at the time that the Convention on IO treaties was being developed, the IFIs as a group were again pretty nervous about this uniform set of rules. But the quarrels, so far as I've been able to unearth them, were really at the margins of the convention rather than its core provisions. I think to get at so anyhow, yes, right, there's the big points are, we have this heterogeneous universe of international organizations. We don't know as much about them as we would like, and I think it's very helpful to identify specific examples of mismatches between the rules that have been articulated and particular organizations that are out there. So maybe I'll say that. The other place where I really want to emphatically agree with Sheila is on this point that the ICJ's advisory opinion comes to a decisive answer about this question of whether customary international law and general principles bind international organizations across the board. So it's something that I have written about. I think if we want to get to an affirmative answer to that question, we need to look beyond that opinion. I've laid out some arguments for how I think you can get there. But again, I just want to emphasize that notwithstanding the fact that that opinion is very frequently cited as conclusive on this set of issues, Sheila, I agree with you that it raises many more questions than it answers.
Sheila, do you want to? I think you should have the right of response. And before we get, there's some interesting questions in the Q&A, but why don't you answer that first?
Yes, no, very happy to. And I think Charles asked a question about the evolving sense of accountability that I'll get to, but just obviously ARIO has played a big role in sort of helping all of us shape the discussion of the responsibility of international organizations. And Christina is right. We do need to have that debate about its potential strengths and weaknesses. Now, I went through, and Charles was on this side of the institution at the time when it was being debated. But at that time, the bank did provide concerns and suggestions and questions, as did many international organizations. But really, to keep the discussion at a more general level, I think it's important to emphasize that ARIO deals with rules of attribution of conduct to international organizations for international wrongful acts, but it doesn't define the content of the international obligations that, once breached, give rise to responsibility. And so it's very fundamental to really do this mapping. And I think, Christina, this is a Herculean task that you're taking on, and we'll be more than happy to look at, critique, join you in looking at, as I'm sure colleagues from other IOs would be interested in. But one comment maybe I'll pick on before going to Charles's question is, there was a lot of interest in what was then Article 63, and which is now Article 64 of ARIO, where the bank and other international organizations recognize the critical role of lex specialis in the scheme of ARIO, right? My colleagues at that time argued that the internal law of international organizations, including its constituent documents, are what govern. And so in some ways, this lex specialis is a very critical part of ARIO, and that it would then leave little room for other types of obligations and under international law to emerge. So what those other obligations are, which we haven't already covered in our constituent documents, policies, and rules, is sort of the gap that I think one should be looking at. My own argument would be, I go a bit further than my colleagues at that time, and that's why I was very careful at the start to say these are my views at this point, is that international organizations should only be bound by the obligations that they have voluntarily assumed under international law. And this really acknowledges the importance of international organizations having an independent legal personality to pursue their mandates, while keeping the purview of the states, through the boundaries of the constituent documents that we have under these state-led bodies. But that being said, Christina, I do take the point that you're making more broadly, which is that we obviously do not exist in a vacuum. And there is international law, which is very critical, but what those rules are, which could apply, which we haven't contributed in setting up, as the states did when they got their own state responsibility rules. We haven't quite contributed to that body of customary international law. And so it's very hard to then argue that they would somehow bind us. And so I would say, Christina, that the comments that international organizations provided at that time are still critical for us to look at, because they did go into questions of attribution. They went into sort of what is a wrongful act. And I think you laid out very well, actually, in your opening, Christina, that an organization doing something that causes harm doesn't necessarily mean it's a breach of international law that would be covered by ARIO. And so there's a lot of ground to be covered, really, before we can say that ARIO is the tool that we would use to determine the responsibility of international organizations for wrongful acts. But Charles, on just very quickly on accountability, and I'm sure that Christina will have some views on this specific question as well. Accountability means different things to different people. But if I were to stick with the most common conception of the word accountability, it's really about bearing responsibility for some sort of wrongdoing that has been done. And I think in that respect, the World Bank has come a long way in ensuring that we have very credible accountability mechanisms, grievance redress mechanisms that really are adapting to the times that we are in, as people's understanding of what accountability means as well. And so you look across the IFIs, you see different accountability mechanisms as well. We have the inspection panel, we have the dispute resolution service, and all these really are to help us make sure that if there are harms caused by the bank's failure to comply with its own policy framework, not with international law writ large, then there would be some sort of redress, a place to have that corrected, pointed out, etc. And the cases have grown over the years, and many have involved violations in projects, violations of our policies, which can obviously be fixed through our legal agreements and our understandings with governments. But I have to say, all the other MDBs, they all have different names, and they're not called the inspection panel, but they all have some sort of mechanism that does that. But the last thing I'll say here is that even with these accountability mechanisms, it's very important to point out something that's obvious to IFI lawyers, but maybe less so to the outside world, is that the World Bank does not implement projects or programs. We provide financing to member countries at their request, and they implement those projects and programs. Now, Charles did point out that we have a responsibility to supervise and to follow up and to exercise remedies when these things are not done. But ultimately, accountability for state actions belongs to the states themselves. And so when we think about accountability, I think we have to be thinking about accountability to whom are we looking at. And I would say that, many of the obligations that, I have to say this carefully, knowing that we are being recorded, but many of the obligations that outside parties tend to place on international organizations arise from a mixture of moral arguments or political sensibilities, are not really from international law per se. And there are many examples I would give. And so I would say attribution is very hard to demonstrate absent a rule that can be said to be violated under international law. And it's an even harder question whether international legal obligations can be specifically identified and attribution linked to an IO. I would argue that the threshold in ARIO is even higher than that. There would have to be a violation of an international law obligation. And so I think the question is still one that needs to be debated. I don't think we're there yet. I don't think there has been enough codification of practice or advisory opinions or decisions or customary, law from international organizations that would say we are ready for an ARIO type convention. Thank you.
So Sheila, I'm trying to synthesize a lot of the very interesting questions in the Q&A and putting my own spin on it. So if I'm apologizing to the questioners if I don't do it in the way they would like. But probably your most controversial thing you said is that the IFIs and international organizations don't make customary international law. It's only the obligations that they voluntarily assume through their articles or through the treaties they sign or in another way. But what about the areas where international law, customary international law, might not be as well developed as maybe it could be, and where the IFIs in particular are taking a leading role? So, for example, in the social and environmental area where the international law is not necessarily well developed, but the IFIs like the World Bank have very well developed and very detailed social and environmental frameworks that are then applied not only in the operations, but through the investigations of the accountability mechanisms as well. So are they not making and being bound by customary international law in that way? And in particular, people have been asking about human rights. And are human rights norms and the way human rights law is developing not a binding or applicable to the IFIs in any way? So we'll start with you and then go to Christina, and Charles, feel free to jump in also.
I'm actually very eager to hear Charles's view on sort of customary international law around environmental impact assessments. People will say that sort of started with, if you want, with the IOs like the bank and others, and sort of were picked up. But there is debate: is that customary international law? Is that, sort of, has it reached that status of customary international law? What I will say, Danny, is that I do believe that international organizations such as the World Bank have greatly contributed to international law more broadly in the areas that you've mentioned, in indigenous peoples, the way environmental impact assessments are done, and things of that nature. Now, would one categorize that as customary, or would that be actually something that is a more formal application of international law? I think that's something that we can debate. The customary international law I was speaking about, which we haven't contributed to, are the ones that states have more or less come up with, and that sit within the state's international law obligations. Those are the ones that we did not contribute to, and so should not be applicable to us through ARIO. That's why it's very critical to mention what those obligations are before saying who is responsible for a wrongful act when they have been committed. So to just to summarize that bit, yes, we do contribute, and we should contribute to customary international law, but the obligations that we're being asked to take on, we did not contribute to, and so it's very hard to say that they are actually binding on us. And maybe I'll throw this one out to Charles to add and supplement.
Well, I mean, I think there's been quite a lot of discussion about human rights and World Bank standards, and I think the World Bank board and those of us who worked on the standards do believe that human rights are embedded in those standards. You look at the rights of people who are resettled or the rights of indigenous people. These are human rights that are provided for in these particular standards. But I think one of the things that's very interesting, and here we get into the different charters and different nuances amongst international financial institutions. For me, one of the interesting questions the last several years has been around the right to remedy. And here, for example, I think it's very interesting that the IFC, the private sector arm of the World Bank, seems to be indicating that in extenuating circumstances, there can be a basis for a remedy to be provided that goes beyond what had been the traditional remedies in the past. And that's where I think we get to this notion about financial institutions that are clearly different than states. I think that, you know, the contrast with UN peacekeepers on the grounds and potentially carrying out the commission of something that has been demonstrated through evidence as a wrongful act, compared to, as Sheila points out, that financial institutions act through the states. And so that's always been this difficult aspect of evolving. How do you fashion responsibilities for the actor who is not the direct actor, but in essence, an intermediary who develops standards that are approved through the charter based of the organization. And so there's that aspect that I think is quite challenging, and why this area of law is so difficult to fit within the ARIO. As everybody knows, it was drafted for states. I mean, they really just drew upon states, not looking at all of the nuances that I think both Christina and Sheila have mentioned to this point. And some of the questions in the chat have been, yeah, what are these responsibilities regarding to supervision? And are human rights really manifest in the way these financial institutions today apply accountability when there are harms through projects that they finance?
Christina, did you want to?
Yeah, I would love to jump in on a few points. So first, I also wanted to come back to Sheila's argument that international organizations should only be bound by those obligations that they have voluntarily assumed. I think it's important to recognize that that's actually a much higher threshold than we insist on for states, right? So when new states enter the international scene, they're considered bound by all of the customary international law that developed before they became states. So we don't really depend on voluntary consent. I think you could tell, if you tell a story about why it's voluntary consent, you're really stretching the concept of consent. I think even if we look at the way that customary international law evolves over time, it really depends a lot on acquiescence and tacit consent rather than states raising their hands saying, yes, I'm on board. So I don't see the case for holding international organizations to this much higher standard than we hold states, is one point that I want to make. I think another point that I'd like to make is, to the extent that we can clarify some of these obligations by having international organizations become parties to the substantive multilateral treaties that regulate human rights, that regulate environmental issues, right? Sort of pick your issue. The way that those treaties are currently drafted, they're open to states only, sometimes states plus regional integration organizations to capture membership by the EU. I actually think it would be very beneficial to open up the possibility of international organizations becoming parties to some of these other treaties, because number one, it's an opportunity to clarify those primary obligations. Number two, it gets to a second deficiency of the ARIO that I think we want to highlight, which is the utter lack of institutions for resolving those kinds of disputes, right? So even if we take the ARIO as setting forth binding rules, we really don't have readily available institutions to resolve those disputes between states and international organizations, among international organizations, right? The ICJ's contentious jurisdiction extends only to states. There are other mechanisms that could be available, right? arbitration, negotiation, but I think we do want to notice the lack of institutionalization as another deficiency in this landscape. And again, because many multilateral treaties come with mechanisms for monitoring and policing compliance, I think there's a lot that's very attractive about international organizations becoming explicitly parties to more of these multilateral treaties. The last thing that I think I want to say now is I think we already have many of the tools that exist that would allow international organizations to make sure the rules that apply to them are suited for them. And I'd like to highlight the concept of particular customary international law, right? So in the state-to-state context, we have this idea of particular customary international law that applies, for example, to states that have developed rules that apply within a particular geographical region that aren't necessarily shared by the rest of the world. I think that this idea of particular customary international law could apply to international organizations as a category. I think it could also apply to subsets of international organizations, right? It's, to me, very easy to imagine rules of particular customary international law that would apply to the international financial institutions as a subset of all international organizations. So I think that there are some solutions that are available to address this lack of clarity about primary obligations, this concern about mismatch between the content of obligations and international organizations as a category or subsets of international organizations. And so I would very much like to see these existing tools used to address some of these concerns that we can't possibly have certain rules of international law binding international organizations because they were created, right, sort of by and for states in the first instance.
We have a couple. Charles, did you want to add something to that?
I was going to say, I think you read my mind. There were a couple other questions that I think are interesting. One is, would there be circumstances where international organizations should be bound for acts that their charters did not envision? And I guess that goes to the question of certain, use Kogan's or customary international law, where, look at, in the case of the World Bank, sorry, Sheila, if I'm putting you on the spot, because this is not your fault, but the articles are from 1945. So, and, they've not changed that much, which goes to a question that was raised in the chat about, maybe this is for Christina, have you seen in the creation of new international organizations where they've tried to adjust to these kinds of issues that we've been talking about? Is there any evolution or new concepts that are being thrust into new organizations?
I'm happy to start, and although I'm going to quote from Christina's own paper on just Kogan's, because I think it's really instructive, and she says the explanation for why just Kogan's norms bind IOs is straightforward. As the ILC explained, just Kogan's norms must bind IOs as well as states to prevent states from circumventing their obligations. And she does go on to note that just Kogan's are many aspects of just Kogan's are contested, but it is perfectly clear that states cannot enter into treaties, especially those that set up IOs, that violate just Kogan's norms. And so she ends by saying use Cogen's norms bind IOs because states cannot by treaty establish IOs that are authorized to violate use Cogen's norms. So, and I think that's persuasive to me in sort of answering a complex question that we still grapple with, how do you define use Cogen's completely? And if that's the case, does it apply on its own to IOs, or should IOs codify what they are? That sort of debate. But I think what she says, nuanced as it is, to me sounds quite clear that why would we be established? A state should not use an IO to do what it can't do under international law. I think that's the basic argument. Then I would say in terms of some of the questions around remedies, the person who asked that is touching on a very live issue. Yes, we have the accountability mechanism, and it's been a debate, and Charles, Danny, and others and know this very well about if an IO or staff in an IO have not followed their policies and procedures, and there was harm as a result of that. Of course, the harm is not done by the IO, it's done by the state party, the state actor. But should there be a remedy on the part of the institution? And we've argued quite consistently over the years that that it's one thing to basically, we've argued, no, there should not be a remedy, a direct remedy to a state party in that respect. However, there are other ways that these harms can be corrected, and the bank does hold its member states accountable to help to correct those harms, and we make resources available in different ways to enable the state parties to do that. I think the critical thing here is, the way we look at remedies essentially is if you are responsible for the harm, sort of that attribution, causation, then you should be the one responsible for remedying that harm. So as a state agent that moves people from land by force, contrary to the World Bank procedures, even if the World Bank has not, maybe did not supervise that project adequately, the remedy should not be on the bank, but it should be on the state to be able to do that, because it breached its obligation vis-a-vis its citizens, and it obviously breached our agreement. It's a long topic, and I realize people will be itching right now to say but and if and and what's happening at IFC and all those things, but that's the current position that we have now. On immunity from suit is also it plays a large part in this whole conversation. Can you sue an IO for breach of an obligation, especially when you don't have what Christina was saying, that gap? Who is the entity that is going to be playing that role, right? So you establish obligations and responsibilities, but we also know that the ICJ only works with states, right? It can give advisory opinions vis-a-vis IOs, but you cannot take the IO to the ICJ. So where do you go if we are immune from suit in a national court, and if you don't have a sort of international mechanism? And I don't intend to answer that question. What I will say is I do believe that with strengthening our accountability mechanisms, individual accountability mechanisms, is a very strong first step that we've taken and we are taking as IOs. Thanks.
I want to approach this issue from the opposite direction in a way, because Sheila and Charles have both appropriately said that the bank, the IFIs lend money. They're not direct implementers of projects or programs themselves, and so that limits their responsibility for whatever harm might be happening. But in the financial markets, the view of the responsibility of financial institutions is changing. ESG is making them take more responsibility for the environmental and social impacts. The lender liability is becoming a more important topic in some ways. The UN guiding principles on business and human rights are saying that financial institutions, as well as other institutions, have responsibilities. How does that affect the position of the IFIs in terms of their responsibility and their ability to to keep claiming that they're not responsible because they only act through the borrower.
Charles, do you want to take that as a scholar?
Well, the first thing I thought of when Danny mentioned that is that even within that field, there are fits and starts. I mean, what we look at, for example, are some of the major financial houses, including some that were trumpeting ESG in the World Bank atrium several years ago, now no longer using the term ESG. And then you have for the founding banks of the Equator Principles, basically the biggest banks in the United States, dropping out of the Equator Principles. I mean, I do think the issue of lender liability is tied into this, and where people are hungering for a sense that financial institutions are probably the most powerful institutions in the world. They control the flow of money. So how do we set their responsibilities at the appropriate level? Clearly, Sheila's indicated this is a system of World Bank Inspection Panel, Grievance Redress Service. There's systems. And then I think civil society, academia are asking, are these adequate given the impact that these institutions have? And it's an evolving discussion. The human rights community developed, the paper on the banking sector, and you mentioned UN guiding principles. But even there, I don't know that the UN guiding principles provide sort of a case study of how you would apply that to a World Bank project. I mean, maybe that's the kind of thing that has to be thought through. And that goes back to my question: what are obligations of due diligence, and to what extent, if there is a failure of due diligence, how much responsibility do you impute on a financial institution? I think that's why this becomes a very challenging question. And you look even at the dissenting opinion of Justice Breyer in JAM versus IFC, and he was uncomfortable to a certain degree of putting responsibilities on the international financial institutions beyond the accountability mechanisms because of the possible chilling effect it might have. I read it 5 years ago, so I may not have all the details correct. But I think this is why this topic is very interesting, why it's evolving, why I've been looking at possibly having this interest group. And we're framing it for IFIs and IMF, but I think it really goes to the entire financing sector, frankly, what their responsibilities are. And I don't know that international law or ARIO really helps answer the question at the project level.
Christina, you look like you were about to say something.
Yeah, so I would I'd love to jump in just briefly. So I think this question of how do we allocate obligations and responsibility between international organizations and states when they are working together is absolutely an important one. And I want to come back to this comment that financial institutions are different, Charles, you had said, because they act through the states. And I actually want to argue that that's a commonality with other international organizations. So one of the first questions that you had teed up on this panel was, well, peacekeeping is obviously very different from what IFIs do, right? The peacekeepers are on the ground, they're doing things in a way that the IFIs don't. I actually see more similarities because those peacekeeping missions, sure, they're set up by the Security Council, and at a top level, they're managed by the UN Secretariat. But in fact, the peacekeepers are coming from states. They're not the UN's own right, members of the military or police. And in fact, the countries that are contributing those troops or those police officers retain quite a lot of authority over those individuals. And when you take that into account, you see the UN is really also acting through the states, even in the peacekeeping context. So there's quite a lot of similarity. And I think actually you get similar questions about due diligence obligations in the way that the whole thing is set up, right? Recognizing that the on-the-ground decisions and actions are going to be taken by states. There are still choices that the UN has in how peacekeeping missions are structured. And there are some arguments, at least, that there are due diligence obligations that come into play there. And you come back to those questions that we were talking about earlier, which is, well, what's the source of those due diligence obligations, right? How confident are we that they exist? How precisely can we define what they entail? So again, I see commonalities here rather than distinctions. And I should say too, right, another common concern that's important is we don't want to let states off the hook and blame international organizations for everything that goes wrong, because actually, right, the states do have a critically important role here. And so we want to take into account the discretion and choices that both parties are making. I do think we want to be cautious to avoid a situation where states are able to shirk their own obligations by blaming everything terrible that happens on international organizations. So that's something that's quite important. And then just the last point that I wanted to make quickly, I wanted to come back to this question of remedies, right? So one place where it would matter quite a lot, one place where I think there is a significant gap, if international organizations are bound by human rights obligations, those human rights obligations that are part of customary international law, the obligation to provide effective remedies for violations of human rights, I think, is quite an important one. And practice here is evolving in some important and interesting ways. In addition to developments at the IFC, I would flag that Interpol recently came up with a new remedial institutions and policies that, again, wrestle with all of these issues, even though Interpol is very different from the IFIs, very different from the UN, but they made an effort to... Oh, sorry for going on too long, I guess.
No, keep going.
Okay.
I think we're just not recording, but we're still online.
But anyhow, the Interpol designed these policies thinking carefully, what did we do versus what did the states do? And I think that allocation of obligations and allocation of responsibility, I just want to agree with Sheila again, that that's really important.
Great. I know we're running out of time, but I wanted to give each of our speakers an opportunity to make at least a final comment. I think we've really just scratched the surface. There's so many questions I still have that I would love to get to, but I think we'll have to agree to have a rematch at some other point where we can go into some of these questions. But I do want to give Sheila and Christina an opportunity to say some final words before I hand over to Charles.
Thanks, Danny. And you know, I don't want to going deeply into any discussion now, but I do want to also point out to Christina's last comment, you know, with the IFIs, we rarely are the sole financer of any project. And many times our financing in big countries like India will be 1% or 2%, or, you know, and even in the tiny countries, it's quite limited. And then you have the state and you have other IFIs, private sector, all contributing to financing the same project. And that's another big challenge when you start to discuss attribution as laid out in ARIO. So the questions are many, and Danny is right. We have really just scratched the surface. But really, I want to end by just thanking Danny and Charles for coming up with this interest group and this first topic, and to Christina for just all her writing and thinking on the topic that I think has challenged us to also on our end think carefully about how we frame ourselves as an actor in the international space, and make sure that we are ahead of the game on these questions. I think it's been a fascinating discussion. I'm grateful to all those who logged on, my own colleagues in the World Bank Group and others as well. And thanks for just the candor and the openness to have this academic debate in a safe environment. Thank you.
Thanks, Christina.
So I would also just like to express my gratitude, first off, to the panelists. Sheila, it's been so wonderful to talk with you about these issues. Danny and Charles, thank you so much for bringing us together. I think one of the things I really value about ASIL is the way that it brings together academics and practitioners, and the panel this morning was an excellent illustration of that. I think also it was an excellent advertisement for this new proposed interest group, because it is clear that there is so much more to talk about when it comes to all of these issues, and it's really wonderful to have this opportunity to do so. So really, my very sincere gratitude for being able to participate in this panel today.
Thank you. I just want to add my words of thanks to both Sheila and Christina. And just to add, as I was listening to you, I was thinking my favorite memory of ASIL annual meetings is many, many years ago, being at a panel of the general councils of the MDBs and asking them a question about the political prohibitions in the articles. And as I asked the question, all of their heads almost simultaneously went down, looking seriously at some paper that they had, and none of them would answer the question. And when I listened to the panel today, I can say that the institutions have moved a long way, and we really appreciate the openness and the willingness to engage. And I think it really says a lot, and we look forward to many more discussions like this. Charles, over to you.
Annie, and I think what you said is a good entry into why we're proposing this new interest group. I think under ASIL rules, we need to have 20 ASIL members, but others can join as well. I've put my email address in the chat. Danny will do the same.
Yeah.
There seems to be a community of development lawyers, of MDB lawyers, who wrestle with the kind of issues that Sheila and Christina have been talking about every day. And what we thought of in doing this is just to provide a forum. It should be light touch, no responsibilities. So I think what we would try to do is around ASIL annual meetings, get together as development practitioners and talk about the evolution of these kinds of issues, these kinds of challenges. I mean, one thing that I had meant to talk with Sheila about, if we had more time, for example, is many development lawyers today are having to switch hats. One day work on a private sector project, and the next day on a public sector project, next day on a guarantee where you've got both together. The issues have become more complex. Lawyers are having to take on more responsibility. Issues of accountability are much more prominent for legal units in the different development institutions. So that's why we were thinking of developing this community of practice. And there will be different views. I mean, there are different advocates for different roles and responsibilities of these organizations. But we think that, if we have this ASIL group, it'll be a good, safe, intellectually stimulating place to have this. We could, if we want, we could develop a newsletter and again, organize things around ASIL events, whether mid-year or annual events. So I think we would be willing to have my email address and Danny's email address to be an initial repository of people who are interested in doing this, and then we could create a listserv later on. Taylor, if you have anything to add from ASIL standpoint, and of course, Danny, please jump in.
Taylor, did you want to, is there anything we should say about how ASIL goes about doing things that we should tell people about?
Or that we got wrong.
Or that we got wrong, yeah.
No, I think you guys did a great job of explaining. No, yeah, I think it's really straightforward. I think you both have a really clear vision for what this interest group would look like, which is exactly what ASIL always wants to make sure, is that it's a very clear and distinct grouping or topic, and it's distinct from any other interest groups that we already have. And I think you all have demonstrated that with this event, which has been fantastic and also fantastically well attended. So thank you to the audience members, but also has really demonstrated that this is a topic very ripe for conversation. So that's been really wonderful. In terms of the logistics, yeah, I saw both of you put your email addresses. So I know you will be compiling the sort of virtual signatures, quote unquote, of people who would like to see this interest group be formed. All of those people do need to be ASIL members in order to be counted. So that's just one thing to keep in mind. But from looking at the attendance list and also from other people who we've connected with already, I think you'll have no problem reaching that minimum number. So yeah, feel free. If the two of you obviously have any other questions about logistics, you can always reach out to me, but I think you're well covered.
Great. Thanks, Taylor. And I want to thank Taylor, you and Brita very much for all your help organizing this. I think Charles has summarized our goal in this well. The main point is, the idea is to create a group where people interested in the same topics can come together, share ideas, challenge each other, but do it in a way that's stimulating and leads to new improvements for everyone, and that it should be people who are interested in the IFIs and development finance, but also in international organizations more generally, so that we can have a cross-fertilization of ideas. People, and it should not just be Charles and I who come up with the ideas for events. We really encourage everybody to contribute and to make use of the interest group once it exists, as a way of encouraging more discussion and attention on these important issues.
Well said.
Unfortunately, people can't really join the conversations. I suppose we'll take it as everybody agrees with us. And to just end off, to say thanks once again to Sheila and Christina for really a wonderful, stimulating and thought-provoking discussion, which hopefully we can continue in some other way in some form. And to Charles, thanks, and to be continued.
Yeah,
anything
thanks to ASIL for providing the platform. So,
yep.
great.
Great.
Thank you, everybody. Have a great
Thanks,
day.
everyone.